Good evening, welcome to the Buck Stops here. I'm Vishnu Shom. On the program this evening, the High Court verdict acquitting Mahmood Farooqui, who had been jailed for raping an American scholar, a friend of his, when she came to visit India. The judgment, more than 80 pages in length, has dealt extensively with the issue of consent in a sexual relationship and has reached the conclusion that, and I quote, instances of women's behavior are not unknown, that a feeble no may mean a yes. Now that begs the question, in the case of sex being forced upon a person, what exactly does an individual need to do? Shout no at the top of their voice? Because often that is just not possible, particularly if a person is threatened, physically restricted and unable to resist. Not because that individual doesn't want to resist, but simply because that person cannot. Does this judgment reverse the path of justice that had been established after India invoked some of the most stringent anti-rape legislation in the world after the Nirbhaya rape case? Well, we're going to move on now with our main debate today, the fallout or the implications of the High Court judgment in the Mahmood Farooqui rape case. What exactly are the implications of this? He's been acquitted after initially being sentenced to jail for the rape of an American scholar who'd come to India. Joining us now to look at this, Kavita Krishnan. She's the Secretary of the All India Progressive Women's Association. Jhuma Sen, Assistant Professor at the Jindal Global Law School. Thanks very much for being with us. KTS Tulsi, the Senior Advocate with the Supreme Court, joins us, as does Majid Memam, the Senior Lawyer. Kavita, let me come to you first. There was one line in the judgment that really sort of stood out. Instances of women's behavior are not unknown, that a feeble no may mean a yes. So essentially, yes and no, which was the basis of consent in the past, or no consent in the past, that no longer seems to apply.
See, the law is very clear on this. In fact, the trial court judgment said this very clearly. Even this judgment says it and then adds a however, that consent isn't just saying no. Consent means that you have to be, it has to be an affirmative consent. You have to communicate yes, either verbally or non-verbally. Now, in this case, the judge is accepting that some incident happened. And he is accepting that the woman not only did not, she didn't communicate a yes, she actually said no several times. So he is not questioning the veracity of her judgment. He is saying, of her testimony, he is saying she is a sterling witness, she has told the truth and all of that. And then after that, he is coming out and saying that a feeble no is not enough, especially if it's somebody who's an acquaintance whom you know, or a friend who has done this to you. I think that is very dangerous. After the judgment, I am listening to a whole lot of young women who are very worried, a lot of women who are very, very upset by this verdict, because they're saying it's hard enough even to find the courage to say no several times, especially when it's somebody known, someone you trust who is violating you. Okay, in this case, you are actually, somebody is doing that and you're being told that's not enough. The entire onus of preventing a rape from happening is being shifted by this judge onto the woman. A man doesn't, why can't you just say that a man listening to no being said several times has to accept it? What is this Bollywood
and
kind of understanding?
The assumption is that no and yes are the only ways for a person to decline consent.
Yes,
it's not. That's just not it. It's not just words. There has to be so much more. Consent isn't only restricted to words. Is what the law also says.
No, it's true. But I'm saying that in this case, this judge is basically regurgitating the Bollywood kind of idea that a woman may say no, but she may mean yes. That is that's taking us back several decades. It's not just the 2012 rape law. It's taking us back decades.
Okay. KTS Tulsi. In that same sentence, in that same paragraph, the judge said that, this was an instance when both parties knew each other, they are both intellectually and academically proficient, and there had been physical contacts between them in the past. Is this justification for this act of violation to have taken place at all? They knew each other, they may have had some sort of a physical equation in the past. Does that justify this particular attack, if I can use that word?
I can't hear you.
Mr. Tulsi, let me ask you again. The judge has said that these are both individuals who are academically proficient, they are intellectual and they have known each other, and that there have been physical contacts between them in the past. Be that as it may, is this a justification for this particular attack?
Is there something wrong with the audio?
Okay, I'm sorry. I don't think we can get. We are able to get him on that line. We'll try and raise him on the phone line if that Skype connection is unclear. Sir, go ahead with your answer. Okay, Mr. Tulsi, go ahead with your answer, sir.
You see, I find that this is a very complex case because there are myriad circumstances. In the first instance, even in the FIR, the prosecutor says that when he kissed her, she responded. And in the email, she says that in fact, it is she who kissed her because he was crying, the accused was crying, and the maternal instincts were aroused in her, as a result of which she started kissing him. No, and then he started kissing him.
False, completely
and
false.
Then
what on earth?
There is a mysterious sentence which he alleges to have, which is there in the FIR, that she responded that it was not what he needed. Now, I don't know what she is suggesting, whether he wants a different kind of sex or what.
This is completely
no, but
Mr.
Tulsi, there is an important letter which has been written, and Kavita, just give me one moment.
Yes, of course, please.
And in that letter, the American student writes to Mahmood Farooqui and says, "You were supposed to be my friend, instead you manipulated me, you hurt me, I said no,
there's another one.
I said no many times," right, is what she says in this particular letter. This being the case, how is it that
he is saying no? This is much later. Her first version comes in the FIR.
Please, I want to say
and
that.
as a result of that, it means that she is, after the accused is kissing her, she responds by asking him that it was not what he needed.
No, but how is this?
This is not there at all. Please let me come in.
Kavita, quickly, Juma Sen, I'll come to you in half a second. Juma, go ahead. Yes.
Yes. So first, I want to state that the court, the High Court, in its judgment, and I'm going to quote the para. It's para 96. The High Court categorically states that the prosecutrix testimony is of sterling quality. So the court acknowledges that the testimony provided by the prosecutrix is of sterling quality, which has been earlier arrived at, something that has been arrived at also by the trial court. Now, there are plenty of passages I could quote from the trial court judgment, some of which has also been reproduced by the High Court as well, which goes on to prove one point. The court goes on and on about the submissions by the both parties, so I'm going to go there. But what is important to note here, and what is important to underline here, that the High Court notes that the prosecutrix testimony is of sterling quality. That is para 96 of you. However, what the court does is, the court goes into a completely in a different track by trying to understand and interrogate consent, whether there was consent involved or not.
No, but Juma, just one,
I just want to say one thing.
Yeah, Kavita, just half a second. Juma, just give me your opinion on what Mr. Tulsi was saying. Mr. Tulsi was saying that the letter I was reading out from, in fact, there's a lot more in that letter, was not what was initially stated, and therefore this letter is not enough.
I will ask Mr. Tulsi to look at para 43 of the Sessions Court order, the judgment. Para 43, and there are these number of pages where letters, communications between the accused and the prosecutrix and also the accused wife have been reproduced.